This is Judge Larry Eisenhower. On December 7, 2004, I interviewed the Honorable K. David Harris, who served on the Iowa Supreme Court from 1972 until 1999. Justice Harris has Parkinson's disease. This accounts for his posture in the interview and also made it difficult for him to speak. After reviewing the video of the interview, it was decided to add subtitles so viewers would understand him better and appreciate his keen mind and especially his dry wit. The additional cost of using subtitles was generously paid for by his former clerks. Join us now for the oral history of the Honorable K. David Harris, the Poet Laureate of the Iowa Supreme Court. At the end of the interview, you will hear Ann Holden Kendall recite one of Justice Harris's poems.
Good afternoon, Justice Harris.
Good afternoon.
The purpose of our meeting here today is to give you the opportunity to discuss your career and history with the Iowa Supreme Court. And I'll be asking a few questions, but I'd ask you to just volunteer anything that comes to mind as we go along. We're here discussing his career with retired Justice David Harris of the Iowa Supreme Court. Justice Harris, why don't you tell us a little bit about your educational background and your youth in Jefferson?
Well, I grew up, of course, in Jefferson. I was born there. It's been my home ever since, except when I was away for a short time for military service and to get my education. My parents met in law school. They were classmates down at the University of Iowa. Mother didn't finish law school or enter the profession, but and the plan was she was going to read law and pass the bar that way. It was quite customary in those days. And of course there were 7 children and she died young, so she never got to make that entry. My dad was a Jefferson boy. He was born there too, back in the 1800s, and grew up there and worked his way through college and law school and entered practice there. So law was a subject of conversation in the home in which I grew up, and I had an interest in it all my life, and I don't think I ever doubted that I wanted to be a lawyer. I practiced with my father until he died in 1957. During part of that time, the firm was Harris, Hanson and Harris. Hanson was Judge William C. Hanson, later a federal judge. And then I practiced with Francis Cudahy and Norman Wilcox until I was appointed to the bench by Governor Irby in 1962.
Okay. Going back to your grade school and high school education, were there any particular teachers that were an influence on you?
Oh yes, indeed. I had a number of them. I had an excellent history teacher in junior high who could really inspire youngsters. I had an English teacher in high school that was inspirational to me. One of the finest educators I ever came across.
Well, you're well known as a writer and as a person who reads a lot. Are there authors that you read in your youth that inspired you?
Poetry has always been of interest to me, and traditional poetry. I've never gotten wired into contemporary poetry. But yes, as a child, I went through the usual Robert Louis Stevenson poems and could memorize those from early childhood. The poetry largely, and then anything having to do with history, which has always fascinated me.
Your father was a lawyer and your mother studied the law. Was it just preordained you were going to be a lawyer?
Well, I always thought so, but I'm one of 7, and I'm the only lawyer in my generation. We sure blossomed out in the generations that followed, but we got a dozen or so descendants of my parents who are lawyers. But I'm the only one in my family, so I can't say it's preordained because none of my siblings entered the profession.
But did you think you were going to be a lawyer all along?
Oh, yes, indeed. I never doubted it.
Never doubted it. Did you spend time in your father's office as a child?
Yes, indeed. Went up to his office on the way home from school. His senior partner, a man by the name of E.B. Wilson, was a sort of a surrogate grandfather to me and my siblings. E.B. Wilson had been a partner of his best friend, whose name was Alma Gates Albert, who served on the Iowa Supreme Court for 12 years, ending in the middle 1930s. And of course, I knew both of them real well in my childhood. Mr. Wilson was, as I say, kind of a grandfather to me.
Now, Justice Albert was from Jefferson as well,
Yes, indeed.
and you'd known him since you were a child as well?
Yes, I knew him, well, I knew him well. I'd met him, and he was kind of a figure in the edge of the family circle when I was a small child. I was about 10 years old when I left the court and he came back in retirement. And I became his yard boy and just loved him, admired him a great deal. And so he was big. He'd probably be scandalized if he knew I was going to succeed him on the Iowa Supreme Court someday. I used to compare notes with Justice Uhlenhoff, and he had a similar mentor who was from Hampton, which was his hometown. It was Justice William D. Evans, who I think by common consensus, strongest judge we ever had on the Iowa Supreme Court. And he was Justice Uhlenhoff's Sunday school teacher, and was the same sort of inspiration to him that Justice Albert was to me.
So you had a childhood infused with lawyers, the practice of law, the discussion of the law. Did you, at what point in your life did you think, well, maybe I'd like to be a judge?
A judge? Well, I didn't think particularly about being a judge until I entered the practice for things. I knew I wanted to be a lawyer, and I've always said I couldn't stand not to be a lawyer. I could stand not to be a judge. I can give that up, not willingly, and I haven't done it willingly, but I couldn't stand not to be a lawyer. So that's always been the important thing to me. I don't think I've ever considered anything else.
Yeah, well, what is it about being a lawyer that is so satisfying for you?
I think my answers to that would be kind of the routine ones you consider. People ask me sometimes, wouldn't your father be proud to know that you became a judge and then both on trial basis and on appellate court? And I say about 40% seriously, and he'd hardly be speaking to me. He was seriously approached by the bar to consider an appointment to the bench, and he acted insulted. He thought his manhood was being impugned. He couldn't understand why anybody would want to be a referee when they can be a quarterback. The role of a judge has always satisfied me. The role of a lawyer is more thrilling to me. They're the gladiators.
Yeah. Let's kind of go through chronologically. Where did you go to law school then?
I went to law school at the University of Iowa.
Recall who some of your classmates were?
Oh, sure. Judge Don Lay, who had a distinguished career on the federal bench, starting at the appellate level. He was a special friend. Judge Richard Peterson from Council Bluffs was in that class. There were just many of them. Several became judges, and we have a couple of professors out east at Duke and University of Michigan. And
what year did you graduate?
I was in the February class of 1951.
How many graduated at that time?
33 in the February class, probably 80 or 90 in altogether.
So did you return immediately to Jefferson and practice?
Yes, indeed.
And what kind of practice did you have?
It was a typical rural Iowa country practice. We, in civil litigation, we played both sides of the street. They didn't divide the bar up between plaintiffs and defendants in those days. We did farm income tax return, everybody's income tax return, and brew wills, probate, conveyancing, just the usual routine.
Did you try cases?
Yes, indeed.
And can you recall any significant ones that you remember?
I got hired to write briefs, both trial, but particularly appellate briefs, early in my career, and that was encouraging to me. That's, I think, when I really started thinking about being a judge. I did not scare the valedictorian in my law school class. My academic performance was not really great, but I was never in any trouble about it. But I didn't graduate with academic honors.
Yeah.
So starting to build a practice as an appellate lawyer, particularly brief writer, got me thinking I could become a scholar.
It's interesting that you found writing to be kind of your pathway into the judiciary. I think that's unusual.
I suppose it is, and that's the route I took.
Did you ever run for public office?
I was a Greene County attorney, and that was, I think, the most unpleasant task I ever had was running for, going around asking for votes. It was a lot of fun being a county attorney. I just loved the work. But political activism never really attracted me.
How long were you county attorney?
I was county attorney about over 3 years, and I resigned when I was appointed to the bench.
And do you recall the circumstances of your appointment to the bench?
Yes, the merit selection of judges at that time under the 5th article of the Iowa Constitution, and the plan had been adopted, but had not yet been implemented. So when my former partner, Judge Hanson, was appointed by President Kennedy to the federal court, a vacancy opened up in the old 16th Judicial District. And by then I had developed sort of an appetite for it. And I didn't mind campaigning for that job because I was just campaigning with lawyers in those days. So Governor Irby, who of course was a lawyer also, and from a family practice in Boone, the next county over, we knew the Doran firm very well. He was the son-in-law of the founder of that firm. His heart was in the right place on merit selection. So he could have appointed any lawyer he wanted to. So but he made a deal with the, I think he did it all his appointments that year. He made a bargain with the local bar that if the local bar association would nominate 3 lawyers for him to select, he'd select one of those 3. And I was one of the 3.
Now this was before the formalized nominating process.
It wasn't in place. It was just, it was enacted but not implemented.
Okay. And it's interesting, you did succeed then, Judge Hanson?
Yes, I did.
Okay. How long had he been on the state trial court then?
About 6 years.
Okay. Now, at what point in your career were you in the military then?
I was in the military before college. Well, I joined the Army Reserves. I went down on my 17th birthday to join the Army in 1944. And they put me in an ASTRP program. I was rolled up and put in uniform and sent to the University of Nebraska for a term, and then the South Dakota State College at Brookings, South Dakota for a term. And it was plain to me that I was not going to win the war in engineering school. So I volunteered for infantry, and they sent me to basic training. And as I tell my grandchildren, the Japanese heard I was coming, so they gave up. But I did get overseas for a brief time.
Where did you do your basic training?
I Camp Fan in Texas.
And then your advanced training, where was that?
At Camp Joseph Robinson, Arkansas.
Arkansas. And then what unit were you assigned to, you recall?
Overseas it was the 7th Infantry Division.
And you ended up in Korea?
Yeah, in a place on the 48th parallel, which divided North and South Korea.
So how long were you on active duty?
Not less than 2 years.
So then it was after you came out of the Army, you went and finished your undergraduate work?
That's right, and then law school.
Law school. Do you recall the circumstances of Governor Irby's appointment? Did he give you a call, or?
Yes, he did. He was not really anxious. I never thought to appoint me. We'd been acquainted. We'd had a falling out on some basis. And but his old law firm, particularly Al Doran, who was a nephew, I believe, he would be a cousin of Governor Irby's wife, was a champion, was one of my champions. And I had some other people who put a lot of pressure on him. He finally did appoint me, and I have thanked him ever since.
Did he conduct an interview? Did you come to the Capitol or anything like that?
No, he didn't. Of course, he didn't have to. He knew me.
Your time on the trial court then was from 62 to 72, roughly?
That's right.
10 years?
About 10 years.
Any recollections about your trial court days that stick out?
I loved it, and there's a difference of opinion on it, but I think it's everybody's prejudiced to the route they took. there's I guess a rule in political science that the iron rule of oligarchy, as it was explained to me in my undergraduate days, that everybody dramatizes and overplays the route they took. I think everybody should do it. But I've always thought that time on the trial bench is awfully important, and if not a requirement, it's certainly a plus and an asset for appellate work.
Maybe this is a question better suited towards the end of the interview, but do you recall the spirit amongst the lawyers in those days when you were either practicing or when you were first appointed to the bench, to perhaps how it was towards the end of your career?
I've noticed that the one constant is in every phase of my career since I left law school, the one unchangeable constant is that everybody in the profession, both on and off the bench, sings the song that it's not like the good old days. That we always got along, and ethics were better, and people got along better, and they all say that, and we all think that. There were some great people in the trial bar when I was a young judge, and when I was a lawyer. There are now, and there is a tendency to think they're not as good now as they were then. But I really, deep in my hearts, I don't believe it. I think it's always uncrowded at the top of the profession, and that's the only place the profession is not overcrowded. But we have some great lawyers now, and we had some great ones then, but we had some stinkers then, and we have some not so good ones now. I have a prejudice about one thing about it. I went down fighting on lawyer advertising, and you notice I wrote a couple of opinions for the court on that subject, and even yet it just horrifies me. I have family members in the practice, and it's a subject that I don't even want to discuss with them because it's an abomination to me. History's going against me on that, and I guess we're losing that. But I think that's a shame. If that's the ravings of an old man, I can't help it.
Okay. Any particular cases that stand out while you were a trial judge that you had the opportunity to preside over, or any incidents that occurred in the courtroom that come to mind?
Well, I think the trial that I remember the best was in Cedar Rapids. In those days we had 21 judicial districts, and it was later lowered to 18 before big reform. It was reduced to 8, and out in the rural areas in Iowa, district judges could not stay busy, and the metropolitan areas like Des Moines and Cedar Rapids and Davenport were undersupplied with judges. So if you put a word in with, we formally didn't have a court administrator with the Supreme Court. We had Clarence Cady, who was, I guess, officially the statistician, but he really was an ex-officio administrator. He'd whisper in his ear and he'd put you to work. So I whispered in his ear and got assigned for several sessions down in Cedar Rapids. And I got along just great with the Cedar Rapids lawyers. Most of them are gone now, of course. That was in the early 60s. But I had a case in Cedar Rapids, civil suit over an electrocution case. Charity Neighbors, the plaintiff, the widow of this electrical worker who was electrocuted. And great lawyers tried that case, and I was just thrilled with it. And they were influential in my appointment to the Supreme Court on both sides.
Did you find that when you had made application for the Supreme Court that all of your experience as a trial judge and as a lawyer, you touched people as you went along who either came back to suggest you wouldn't be a good Supreme Court justice or you would be a good Supreme Court justice?
They were a big help. It seemed like everything was preordained. And that's certainly true. And it's amazing how the pieces fall into place. One of those lawyers on one side in that case was very influential with a lot of the nominating commissioners. One of them on the other side was a nominating commissioner, and I can hardly tell this incident without almost choking up, and it moves me so much. But the one who was on the commission, and this is a real lawyer. I mean, a real lawyer. He went to his grave later thinking I was wrong. I refused to direct a verdict in his favor, which he thought I should. I granted post-trial relief to his co-defendant, left him holding the verdict alone. He appealed, and I got affirmed, and he thought I was wrong at every important ruling in the trial. And another commissioner who was a friend of mine said he got up and announced that he had this one experience with me and I was wrong in it, but I still think he's a fine judge and should be on the Supreme Court.
Well, let's talk about your efforts to get on the Supreme Court then. By then we do have the statewide
Yes.
commission, and you had to deal with the commission, and who was the governor at the time?
Governor Ray.
And how many times were you nominated?
I was like Bob and Ray's Overstock Warehouse. I didn't have much trouble getting nominated. I half seriously applied for it when Justice Reese was appointed, but when I found out he was interested, I wouldn't run against him. He was probably my best friend. I'd gotten well acquainted with him down in Cedar Rapids, but I ran the next time, and I was nominated all 3 times with a judge from Storm Lake, a district judge from Storm Lake. And the third nominee the next time was Justice Hewlin, he got appointed. The next time it was the same judge from Storm Lake, Judge Dick Cooper, and a country lawyer I'd never heard of by the name of Ward Reynoldsson, who ended up being the auctioneer's brother-in-law. And I thought I'd get appointed that time. And the next time I was nominated with Judge Cooper, and, oh, forgive me. Anyway, I was one of the nominees the third time, and I didn't think I was going to get appointed that time, but that was the time I was.
Yeah. In those days, were you expected to go personally meet with each of the commissioners and introduce yourself? And
You were.
yeah.
And I've heard it said that I've been blamed for starting that practice, but I think it was in place before I did it.
Once you were nominated, you come down and interview with the governor?
Yes, that's right. Each time.
Do you remember the call from Governor Ray?
Oh my, yes. He wanted to have the governor call you. He didn't want to have his assistant call you. And the third time when I was sure I wasn't going to get appointed, the telephone rang and said it was in the Supreme Court. And his assistant said, voice came on, I thought, oh my, you got here? I said, yes. I was in Chambers up in Rockwell City. And he said who he was, and I said, yes, my heart sinking. He said, just a minute, Governor Ray wants to talk with you. And there was a rumor, I think I mentioned in my retirement ceremony, it was a dirty lie that when the governor told me there was a meeting of the court on the legislative reapportionment case, which is really a tremendous importance in Iowa. The court was going to meet the next day, and the morning could I be there, the story was told. I say it's slanderous. It's not true that I arrived at the State House with the telephone still in my hand.
But do you recall what he said to you? Anything in particular?
Yes, he said, are you busy? I said, well, no, I'm going on. You know, if you're busy, I can call back later. I assured him that I could arrange to talk with him. He told me like that for a while. Then he told me that about the meeting in Des Moines, wanted to know if I'd like to be there. And I was willing.
So that's the way he put it to you.
Yeah.
There's a big meeting in Des Moines. Would you like to attend?
Oh.
Well, how long did it take you to wrap up your trial court business and get down on the
Well, that
court?
is a good question. Less than a week, well, maybe 10 days.
Just
I was always current in my ruling.
did we have the 90-day rule in those days? You had to
No.
report cases.
No,
If we had had that rule, would you have had any day report?
I never would have in my career if they'd had a 30-day rule, with one exception, one I forgot about, when it came in with about, a dozen non-jury trials.
Well, that raises an interesting issue then. What was your practice if you had a bench trial and it took a couple of days, a divorce or something? What was your routine as to how
Well,
you would get those out?
My routine was to dictate the findings of fact to my reporter, and maybe the ruling if it was appropriate, was just a slam dunk. If there were briefs to be submitted, I would still dictate the findings of fact at that point, and wait for the briefs and apply them to the facts I had already found, and it takes some intellectual honesty to remain loyal to the facts you dictated when the iron was still hot, because sometimes you want facts say, well, isn't that sort of my case? And if they give you an easy, quick exit, but almost all my non-jury matters were my ruling were out within a week or 10 days.
Did you ever rule from the bench in the presence of the parties and those kind of
I
cases?
didn't. There's an interesting story about that. I was in a debate. I was in the first class of the National Judges College in 1964. It was in the first 2 years in '64 and '65. It was held in Boulder, Colorado, and Justice Clark was there. Incidentally, he founded it. Justice Tom Clark. And Ernie Friesen was he was the secretary for the Joint Committee on the Administration of Justice, and sort of a protege of Justice Clark. And he was the first dean of the college and set it up and ran it for several years. I ran into Ernie Friesen at a conference for juvenile court judges. That was a very important part of being a country district court judge. And I went to one of their training sessions out at the University of Colorado, and it wasn't a university, it was at Aspen Lodge. And Ernie Friesen was there, and I noticed him there and didn't know him. I introduced myself. He told me what he was doing. I said, he said, I want to see how this is done with T groups. I said, we're setting up a National Judges College. And I said, I want to attend. And he said, you and about many thousands of other ones. And I said, well, I really did. So I made friends with him, found out a little bit about him and his sense of humor, and I did get in that first class. So I kind of lost the question I was answering at that point.
Well, the original question was ruling from the bench.
Now, that led to a debate. There was a judge from Kentucky who took the position that traditionally you never know more about the facts than you do at that time, and the parties can hear from the lips of the judge, and you get your rulings out. And I agree that you should get your rulings out, particularly the factual part of it. But it just scandalized me. I think you got to hate lawyers a lot to want to embarrass them in front of their clients. They haven't settled for the fee at that point. Might not even, in those days, might not even know what it was going to be. And I thought you'd have to be terribly mean to meet somebody. We tell jurors to keep their mind open until the case is submitted. And if you're going to move from the bench before as the echo of the last witness dies, the parties are not going out there thinking you keep your mind open. So and we took this debate, and the National, they had a newsletter, I wrote a couple of articles for it. But I took the position that was terrible, and this judge from Kentucky took the position it was the thing to do. And I don't know who won the debate, but he got invited on the faculty of the National Judges College, and I didn't.
You know, it's interesting because in our state, as you well know, there are areas of our state where it's a common practice for those judges to rule from the bench, and there are other areas where it's never done.
There's we debated that at the National College that year, and there was a judge from New York, intermediate appellate judge from New York, been a trial judge, much experience. And he said when he became a judge back in the late 20s or early 30s, they had a judges convention, and they had a guest judge from England who was attended there in New York. And the same debate came up. And he said, you know, these things aren't new. We had that debate back in England back in about 1910 or 12 when I was in bench. And he said they got the judges, only 250 judges in England, you know, but they're very influential. He said they sent the judges back home and deal with the usual arguments. You hear from your left. And he said the one judge from Liverpool went back home, and the next week he came off the bench and went in chambers, and the bailiff was helping him out of his wig and off of his robe. He said, damn, I did it again. It's the third time. You did what, my lord? He said, I said plaintiff, and I meant to say defendant.
Yeah, that can happen. Well, I guess we're up to your ascending the high court. Do you recall who your colleagues were on that
yes, indeed.
initial day?
I sure do. Chief Justice Moore, Justice Mason, senior to Justice Mocha Rawlings by about 10 minutes, and they were sworn in the same day. But Mason first really held seniority, and it was very important to him that he was senior to his colleague. Then Justice LeGrand was in third place in the rank. Then Justice Becker, maybe Becker was senior to, I can't remember whether Becker came before or after LeGrand. I think he became, before he was appointed by Governor Hughes. Frank Becker, then Justice Hugh Hopkins, and Justice Reynolds, and then me.
Mm-hmm. What was your relationship with Chief Judge Justice Moore?
I just, everybody liked him. Justice Moore, the chief was very streetwise. He was from East, by God, Des Moines, he would say himself. He graduated from East High. Delightful man, just knew everybody in the Capitol by their first name. And total recall on their family, everything about them. Just an absolutely delightful man, and I only got in one quarrel with him, and I was wrong in the quarrel, but Justice McCormick and I took a position contrary to one of his ambitions. And I went to talk to him about it, and I said, Chief, I'm kind of a team player, I hate to cross you, but I think you're wrong on this. Yeah, he wasn't, but I thought so at the time. And he said, that's all right, Dave, you come after me. He said, swing as hard as you want. You'll find out I ain't no virgin. And I sure did, because I spit out teeth for a long time. Mm-hmm. Justice Mason was a great big gregarious Irishman with a hot temper, explosive temper, and a great heart, and say terribly hurtful things, and wonder 5 minutes later why you remembered it. He didn't. Justice Rawlings was a sort of a Don Rickles, notoriously funny, kind of sour guy. Justice LeGrand was a, how would you describe him? He was a professorial type, brilliant, aristocratic, towering intellect, class guy. Let's see who was next. Then was Frank Becker was near the end of his career because he resigned that spring, going back into practice here in Des Moines. Justice Reynolds was, of course, a country lawyer like I had been, and had not served on the trial bench. And Justice McCormick was a boy wonder. He was brilliant, of course.
Now you replaced Justice Stewart, did you not?
That's right.
Yeah. So you can thank President Nixon for your
That's right.
appointment.
That's right.
How long was Chief Moore on the bench before he retired after you came?
Me, about 6 years.
Okay. And then Justice Reynoldsson became Chief Justice?
That's right.
Do you recall the circumstances of how that happened?
We just, he'd been, the position of acting chief, the Chief Justice in those days would appoint one of his colleagues as acting chief, and it was rather more important than it later was under other chiefs. And he took over. And there was a contest. It was not unanimous. Either Justice Reynoldsson or the other one would have made a great chief.
Okay. Well, do you recall then that first session you sat in on and the reception you received from the fellow justices?
And the very first session?
Yeah.
Well, I certainly do. I wasn't sworn in at a public ceremony until the arguments were due in the legislative reapportionment case. So I was sworn in, my family was there, they came in from all over, and my bride took the family over and they had a celebration afterwards over at the hotel, and I sat down on the bench and heard the case while they were celebrating my swearing in.
That case was had a lot of, that was pretty controversial
Oh
case.
my heavens, yes. The court, I guess as everyone knows, gave up on the legislature. As the Constitution says, it is the duty of the court to do. And we drew up the boundary lines for the election districts for both the House and Senate ourselves. And the first computer I ever saw filled up a whole room with equipment. They sent the legislative reference bureau, what do they call their?
Legislative Service Bureau?
Yeah, they sent a computer expert, and we drew the lines.
Did you do that after a hearing, or what was the process?
And we had a hearing. I can't remember all the hearings. The first hearing and submission was whether we would do it. And then we'd do it and file a report, and then we had a hearing on that. And it was mathematically perfect. Of course, we went up alleys and around houses. It was mathematically perfect. Every Senate district was composed of 2 House districts, and the lines were exactly the same, and the balance was perfect.
So you were in 2 more decades. Did you ever have to do that again, or get to do that again?
Almost 3 more decades. No, they got the word, and they did it satisfactorily after that. And we're glad. We're glad.
Did you sense any isolation from making the move from the trial court to the Supreme Court? And did that bother you, or did you adjust to that?
It did bother. And I've known colleagues that it bothered even more. It's well, you're an appellate judge and you've been a trial judge. You know that a trial judge is with the bar. I used to have an opening line when I talked to lawyer groups after I became an appellate judge for a while. I tell them a story that's not entirely true, but it illustrates the point. I said that I served on the trial bench for about 10 years, and I got to thinking I was very witty, and I could tell stories, and I could get a lawyer slapping their knee in hilarity, and then I got appointed to this court, and I lost my authority to fix probate fees, and I haven't had a laugh out of a lawyer since.
That's right. Why don't we take a short break?
Okay.
How's that?
You asked about cases that I thought were interesting or important on the appellate level.
Yeah.
A case that gave me a lot of satisfaction, we really contested that on the court, was the opinion I wrote in Funderman, F-U-N-D-E-R-M-A-N, and I can't give you the site, but it was the case in which I finally got a majority of the court, a 5-4 decision, to abolish the right to recover for alienation or affection. And it was very hotly controverted. I came on the court wanting to get that abolished. I had some experience with those claims, and I never saw one that I didn't think was an extortion plot. The idea that I had a typical situation. I had a wife, and she loved me and thought I was great, and I loved her. And we had this relationship that was everything. And then this paramour slipped in by stealth and stole those affections from me. That never happened in the history of the world that way. The first place, she's not my property. And the second place, he's not going to be able to steal them if it's the way I describe it. It's not stealable. And I felt very strongly, and of course the others on the court, led by our chief, Reynolds, it was the work of the devil. We had that was one of the few cases that got so serious that we stopped joking about it. The swing vote on that was Justice Hewlin. He changed his mind on the basis of my opinion. And I'm still very satisfied with that ruling. I look at where it's cited in other appellate courts around the country, and they're not very impressed with it. I still believe it was right.
You've, of course, in your practice in the law, lived through the days of fault divorce and into no-fault divorce.
Certainly.
Did that play a part in your alienation of affections?
Well, it's the same sentiment, I suppose.
Yeah.
I never thought of that. I was appointed after the work was done. We were just closing it up. I was appointed to a State Bar Association committee that was drafting the no-fault divorce thing. As I say, that was done before I was appointed, but I was in on the last round of it where we sold it to the legislature. And I think I often say that's about the best improvement in my whole lifetime, is getting rid of that, the fault divorce. That was a hideous thing. It embarrassed me to have people come in with I'm a Roman Catholic and certainly believe in the permanent wedding vows, but to have marriages on the rocks, people, neither of them think it can continue, and then they, typically in my practice days at least, it was the husband that made it so impossible for the wife that she wanted to be driven to leave, and yet wouldn't let her go until she gave up support rights. Mm-hmm. It was a terrible thing.
Along that same line, sort of along that same line, you've seen in your career the advent of women entering the profession and ascending the bench, and what's your thoughts on that?
Well, as I say, my mother didn't think the profession was open to her, and it wasn't. She couldn't vote when she left law school in those days. I think it's, although she's got 2 granddaughters and 1 great-granddaughter who are lawyers, and I think it's great. There's Albert, who, as I say, was kind of an ancestor of my law firm, was against women's suffrage. He didn't think women would make conscientious jurors. And I was up in the Greene County Courthouse in Penland in a grand jury back in the 60s. And I looked at the panel in my own county. I looked at the panel and I thought, my heavens, there's not a woman on that panel. So I waited until recess and went down to the auditor who was on our system, picked the jury, or picked the panelists, and asked him about it. Well, women aren't supposed to be on a grand jury. And I said, where did you learn that? And he had instructions from upstairs, and I'm sure it had been Albert who didn't want him on the jury. And I said, you get rid of that, and we'll have the press in here and get a scandal that we won't be happy with. And the next time I swore in the mid-60s, swore in the first woman ever to serve on a grand jury in Greene County.
Once you got on the Supreme Court, of course, you were entitled to have a law clerk every year, and I understand you had about 27 of them, is that correct?
27 law clerks. And that was one of the two great things about being on the court. The first thing was the relationship of the members of the court. But a close second to that is, maybe equal to that, is my relationship with my law clerks. I'm so proud of them and fond of them. They've all done very well.
Keep in touch with them?
Oh, yes, I hear from them. I got one's a vice president and counsel for Notre Dame University, and I've got a judge in the county over, and two judges now. I got one here in Des Moines, one in Ames, who were law clerks, and a lot of successful trial lawyers all over the country. And they were like sons and daughters.
You even had a husband and wife that were clerk for you, right?
The one at Notre Dame, his wife was a law clerk too. She was here in Des Moines. They both were.
Do you keep in touch with them?
You bet. I hear from them.
And you have a rogues gallery of them in your
And my
office?
chamber's up in Jefferson.
Okay.
I'm an amateur photographer, and I took pretty good portraits of each of them and have them in matching frames. Well,
I asked you about this earlier as it related to your education, but you're well known for your brevity and the conciseness of your opinions. How did you develop that?
Well, I always say that I can tell everything I know about any case in about 4 or 5 paragraphs, because I don't know much about them. And I've got some 8 and 9 pages of opinions that prove that point. The writing's always been important to me. I love to write. If I'm a poet. It's not true that I published any poems in New Yorker, and that was suggested one time. But I have published poetry in Good Housekeeping through the years until they stopped publishing poems. So writing, any kind of writing, is very important to me. But they thought my writing was acceptable. I've had encouragement about that all my judicial career. But a big break for me was to attend a writing session, training session that I attended at Boulder, Colorado, back in the mid-'70s. It was conducted by a man by the name of George Rose Smith, who wrote a primer for appellate judges writing. He was a Supreme Court justice in Arkansas, and famous for his writing style. I attended that session. Part of the training was to send an opinion every month that I filed, and he'd send it back the way it should have been written.
Oh, really?
And it was a humbling experience, but you soon learn to cut word flat. And he had on the faculty out there some students of prize-winning journalists. And journalistic style of writing is, I think, should be the goal of appellate writers. The simpler, most direct way to say it is always the clearest. And 90% of the trouble I've gotten in my career has been for things I said. Very few examples can be found where I ever got in trouble by not saying something. So brevity should always be the goal. Justice Smith always said, there is no good writing, there is only good rewriting. Even though it takes longer, you can always boil it down.
On the Supreme Court, I presumed you were assigned to draft an opinion, and then you circulated the draft amongst your colleagues. How did they feel about this brief writing that you did?
Well, they were always fine about it. They always liked it all right. I presume that I rather assume on the basis of how they wrote their opinion, some of them, they thought I was being too summary and too flippant, but none of them ever said that to me. I got in trouble one time for writing a short per curiam opinion. I wrote a per curiam opinion of a highly controversial case. It came out of Poole County, and the I was a freshman on the court, my first few months on the court. And I was being encouraged by one of my colleagues who was also new on the court to write it that way. And it was, and the gun was loaded. I didn't know it was loaded. The losing party in that case could hold press conferences. And the court was accused of being flippant with a fundamental right. And we took a lot of bad press and editorials for a long time. And that hurt a lot. It didn't do my crusade to have simpler opinions any good. But I've outlived that.
That raises an issue. Ever in your judicial career, have you ever felt threatened by litigants or anybody?
Oh, yes, indeed. I have been threatened by litigants. The court administrator called me one time in the afternoon and said this person, who happened to be a lawyer, and made threats about me, and told me to get the police to cover me until I found out where the guy was. And I did. Policemen followed us around that night, and we went out for, we'd been invited to dinner with a guest, and we went back to our home. The local police went clear through our house to make sure I wasn't there.
Yeah.
It's not a routine. My dad said one time, I went in and tell him this client of ours had wanted me to go down and close out a business that he had sold, and somebody in it defaulted. They were trying to close him out. And I said, sure, I'll go down. He was scared. He said, this guy said, is quoted as saying that he's going to shoot anybody that came in to do that. And I said, what do you think about that? And my dad, who was, in addition to being a country lawyer, had a long military career. And looked out the window and said, well, if you're going to practice law, somebody might get mad enough at you sometime to shoot you. But he probably won't say so before he does it.
I recall sitting in on an argument over in the Supreme Court, and I don't remember if you were on the bench yet or not. Had to do with when Judge Bound had a weapon on the bench over in Jasper County, and the oral arguments concerning that. Do you recall that one?
I do, but I can't remember the outcome. I remember the incident.
I remember the bench got into discussion of the incident back in the 30s when the judge was taken out and the rope was put around his neck.
Up in Lamar's.
Yes.
On the trial bench, I had a kind of a touching thing. I had a man that said he was going to shoot the judge if he did what I ended up doing. But he must have told every lawyer in Fort Dodge and surrounding cities that he was going to do that. And they all tried to talk him out of it. And I went up there to ask the clerk and bailiff to get an extra protection in the courtroom. And the sheriff thought his ability was being impugned, so he didn't do it. He showed up himself. And but I needn't worry, because here were all these lawyers that this guy talked to, and they're all sitting around there like detectives in a Grey Blue movie. And if he would scratch his arm, I suppose they'd all shot each other.
One of the things that you became later in your career on the Supreme Court, of course, was chairman of the State Judicial Nominating Commission. How was that experience?
That was a good experience. There are a lot of course, the proceedings are secret. I can't share all that with you, but for the most part, it was excellent. There were a few people carrying crusades or causes that were partisan, shouldn't have anything to do with it. But by and large, they were very well motivated, and I think the system worked very well. I was from the time Judge Uhlenhaupt died, I was chair of that commission until I left the court.
Any comments on our judicial appointment process?
I think it's superb. I asked a appellate judge from the Texas Court of Civil Appeals one time how much it had cost him to run for retention or for re-election. And I think I suppose the figure twice this now or three times. I think he told me at that time it cost him a little over $3 million to run. And I said, where do you get that kind of money? He said, we get it from law firms, but they don't expect anything for it. And I said, well, I looked at that. He said, how much did it cost you to run for election? I said, 26 cents. I had to buy a stamp. I went down and talked to the Georgia Bar Association one time. No, not Bar Association, Georgia Judges Association. And tried to sell them on the plan. I told them that story about what it cost them. And I said the administration and the Secretary of State have got to remind us when our terms are up, because we don't pay any attention to it. And I tried real hard to sell it, and I didn't sell it to any of them. They understood the system, and they had come in, and they were afraid otherwise. Even though a judge down there confessed to me over a cup of coffee that he had a capital murder case coming up in his trial that next summer, and he was up for re-election in November. He said, if that man is not sentenced to be executed, I'm out of a job. There's no question about it. I just think that's hideous.
How did you see things change from the time you were appointed to the Supreme Court until your official retirement? I know that it seems like there's a lot more administrative duties than there were.
A lot more duties, but the case management is excellent, both in the trial bench and on the appellate level. I think, again, I think our system is matchless. I think it's just beautiful the way. If I were to tell you how we handle case flow management in the trial bench in the 1960s, it sounded like we were in the dark ages.
Yeah.
The backlog when I came on the court was average from appellate notice to procedendo was over 3 years. Some of them got 4 and 5 years. And we just took charge of it. And that's the big change.
You were on the court when the Court of Appeals was created.
Yes.
What recollections do you have of that process?
Well, the Court of Appeals was the pet project of Chief Justice Moore. I always thought it was kind of a monument to him, and there's just no question about the fact that it's not only a leap forward, it's absolutely necessary to have a Court of Appeals. I've had the honor of working a little bit with the Court of Appeals as a senior judge on the edges of time or two, and my respect for that court and pride in it is great. I just think it's fine. The people would have to. I don't know how the system would work without it.
Right.
And incidentally, I like our Iowa system is not a typical one. All appeals, as you know, come from the district court to the Supreme Court for processing and routing. And most systems have a 3-tiered. They go just to the district court and to the intermediate court, and then only on writ to the Supreme Court. And I've heard it argued that that's a better way, but I'm not sure. I like the system. It seems to work for us.
You have served on both these Court of Appeals and the Supreme Court as a senior judge, and how do those experiences compare?
They're quite the same. The motivation, the dedication, and the work habits are very similar. I think that when the Court of Appeals was established in 1976, there was a little bit of talk of sending Justice McCormick and me over to serve on that court for the first 6 months. But it was decided before that was suggested formally that would be too patronizing and they wouldn't appreciate it, so we didn't do it. But it would have been a wonderful experience for us. I wish I could have been over there before, at that time, because I'd have understood it a lot better.
I hadn't heard that before.
That was just discussion.
The discussion, sure. Well, let's talk about just some other things in general. One of the things that Justice Larson talked about at your retirement was your so-called baby orders. When did you start doing those?
I can't remember. It was sometime probably in the 70s, early 70s. It's just one time years ago I saw a will, a copy of an apocryphal story about a will by an old lawyer who was a derelict in Chicago about leaving the parks and the meadows and everything to lovers, and it was kind of a beautiful document. And when somebody had a grandchild born to a member of the court, I thought it'd be kind of nice to have a document certifying that baby. I don't remember whether it was a boy or a girl at this time. Certifying it as a duly constituted little girl, having ordering and certified, getting all these achievements and recognition and good things, and it just kind of developed after that.
Did you, was there a unique one for each child, or was there?
Well, they got to be kind of routine after a while.
Yeah.
I jimmied a little bit and improved it through the years, I think. But if you had 6 or 7 or 8 or 9 or 10 grandchildren, and Judge Larson did, you see similarities. They're almost the same.
So you had a boy one and a girl one, and
Yeah, that's right. Okay. I still sign one of those every once in a while. I got sort of a form, but the court doesn't, of course. But I sign one as a magistratus on my own right.
Okay. Now you're still a senior judge on the Iowa Supreme Court. Is that correct?
Iowa Supreme Court, and I guess Court of Appeals. That'll last until next July.
And then the mandatory retirement age for that is what?
78.
78. And how old are you now?
I'll be 78 next July.
Okay. We haven't talked about your family too much. You have a wife, and her name is what?
Madonna.
And how many children do you have?
We have 3 so far.
So far, you still hope? And where are they?
Our older daughter lives in Jefferson. She's married to the county attorney up there. She is department head of the sociology department at DMAC Boone Campus. She teaches the psychology courses there. She has her PhD from Iowa State, and our second daughter lives in St. Paul. She's a music teacher in the parochial school up there. She's had a long career in music education. She was for many years until she had some burnout. The director of music at Boys Town, directed Voices of Boys Town choir on tour a few times. Our tail ender is a lawyer, a trial lawyer, and he's been practicing in Omaha with an Omaha firm, but he just made an arrangement for a lateral transfer, and he's joining a Des Moines firm next month.
And how many grandchildren do you have?
We have, by the older daughter, we have 2 granddaughters. And one of them is a lawyer. She just joined the Des Moines firm. And her older sister is a music teacher in Prairie Gowrie, near home. The daughter in St. Paul is single. The lawyer from Omaha, moving to Des Moines, has a little red-headed boy who's 7, a little red-headed girl who's 3, and a little girl just adopted from Guatemala who's not red-headed.
Okay. Any great-grandchildren yet?
No.
No.
None of the grandchildren are married.
Oh, okay. The poetry we've talked about just briefly. What got you started doing poetry?
It was very important to me as a child, and it's a terrible thirst. The problem with it is there's so many hacks and so much doggerel that it's embarrassing that a person hesitates to get very much in it. They came up in the register and ran a story about it one time. And they did a film on it in Living in Iowa on public television one time. My poetry is, most of it, the kind anybody can see, is pretty serious. It's traditional, sonnets, formal, traditional values and ideas. The kind that poetry editors don't get caught, generally caught dead publishing.
Have you published volumes or no? Some magazines and...
The only national magazine was Good Housekeeping.
Well, one of the things that I recall from reading the transcript of your retirement ceremony was the references to Justice Reese and the Reesisms. And again, I think you have a file of those, or there's maybe that's apocryphal as well.
No, I have a file of Reesism. They range from politely risque downward and on. Reese was a very, very witty person. He was a tremendously interesting person. He had a genius for making people like him, and he could get the court wives giggling over things that they threw their husbands out of the room, out of the house for saying. He was very lovable. When I held court in Cedar Rapids in those days, I don't know how many lawyers would say to me, "Well, you're such a friend of Judge Reese, you already know this, but the Reeses and my wife and I are the closest friends. We're the closest friends they have, and they're the closest friends we have." It seemed like everybody in the Cedar Rapids bar said that, and they all meant it because to them it was true. But and on the court, we've been friends, of course, on the trial. We were both on the trial bench. And when I joined the court, he was. I recognize everybody loved him for that. He could break the tension. Every time anybody started to get angry, he'd say something that just put you on the.
Now, did he come on after you were on?
He came on less than 2 years before I did.
Just before. You were on the bench when Justice Newman came on and
Yes.
became the first woman on the Iowa Supreme Court.
I was chairman of the nominating committee.
Do you recall how if that changed the kind of the chemistry of the group at all?
Well, Justice Schultz has been quoted as saying it cleaned up Harris's stories real fast. Actually, she was, in retrospect, I think, the perfect selection to be the first woman on the court. She was much too busy doing her work to be selling feminist ideas.
Mm-hmm.
She was very professional and very bright, and absolutely just what you'd want. She was courageous, and I think did a perfect job. I think the court could now stand less talented one, but she was a perfect first selection.
Mm-hmm. Anything else come to mind as we're just sitting here?
Well, I don't know.
You're doing a tape that will be seen perhaps 50 years from now, or it might be seen 100 years from now. And
I said at my retirement party that they've had a lot of. I served with about a fourth of the Iowa Supreme Court justices in our history, and I've been thrilled to be associated with them. Not one of them ever did an unkind thing to me. They've all inspired me with their dedication and their ability. When people 50 and 100 years from now look on our history and our opinions, they may see things that were quaint. They'll never find any member during the history that was more thrilled to be here than I was. It's really been a privilege, a dream come true for me.
mm-hmm.
The future generation to look a little more deeply into our history. When I left the court, I had hoped to write a history of the court, not in the tradition that Lord Acton and Professor Acton did in their wonderful book, which traces the important history of the court in terms of what the issues I was going to write a history of the justices of the court, to expand on that little book that they hand out.
Mm-hmm.
There were some sources for that. Somewhere up in my chambers, I've got a list, incomplete list, of where the biographies of the justices can be found in their reports. In later years, starting in, I can't remember, maybe after the turn, after the early 1900s, they started putting those in the front of the Iowa report. And when they stopped publishing Iowa reports, they're in the front of the Northwestern Reporter, and you can find out a little bit about the justices from reading those. In the very earliest Iowa reports, they're not in the front, they're in the appendix in the back. And they're not found by a lot of people, but a lot of those early pioneer justices, you can find a rather extensive biography. They're a little hard to find because they don't coincide with the retirement. In those days they were political, and they didn't leave willingly. And they left with some bad feelings. They waited until they died, which might be 20 years later. And but they're in the appendix back then. And those should be consulted by future people interested in our.
Now, are you still working on that?
No, I'm not working on it. The chief wanted me to write that, and it was going to be funded, and funds, as you know, in the court system are.
Justice Labarato, you mean?
Oh, no, it was
Or Reynoldsson?
McGivern.
McGivern, of course. You care to comment on the styles of the various chief justices you've served with?
Well, I mentioned a little bit of the personality of the 8 who were here when I came on. If I didn't do anything now. I didn't mention Judge Albee or Judge Woolley or Judge Schull or any of the others. They've all been. We never had a member in my time that lacked some quality that the rest of us could have profited by imitating. They've all had unique gifts that they shared with all of us. They're good people.
Harbor Lights of Grand Marais by K. David Harris. The harbor lights of Grand Marais keep beckoning to me across a broad and silver bay beside a northern sea. At Grand Marais, twin beacon lights shine out to boats that roam far out at sea through watchful nights to lead them safely home. Though I have never owned a sail, nor ever gone to sea, nor ever faced nor felt a gale, those lights are dear to me. For they shine also toward the land from dusk till coming day, upon the open heart and hand of lovely Grand Marais. And as I wander up and down along life's northern shore, my dreams end always in the town where I would be once more. The harbor lights of Grand Marais keep beckoning to me across a broad and silver bay beside a northern sea.